good morning again, everybody. We're going to get started. It looks like everyone's here and settled with the donuts and things. Again, go up and get some more donuts and coffee if you would like to. And I thank you all for being here today with my second annual client meeting with Taking Over Ownership. I'm really happy to see you all here, and thank you for your support and everything, and being here for me as I continue to transition into my second year from Taking Over from Hannon. So what we're going to do first is we'll go through your packets of information in your folders that we have there. And can everyone hear me okay? And everyone in the back, give me a thumbs up. Perfect. And everyone can see the screen okay in the back? Perfect, perfect. Okay. I am going to stand kind of in front of the screen here a little bit as we go through your packets. So I need a table. Or maybe it makes sense if you guys don't mind. I might use your table here. Okay, so on the left side of your packet, you'll see that biography of me. So we have this in here every year, and a couple of things of note are that I'm the co-author of the Medical Assistance Planning booklet that our office puts out, and I'm a member of the National Academy of Elder Law Attorneys. I'm part of the MSBA Medical Assistance Committee, and I am now part of the Wyndham Chamber board here in town. So that's a new thing that I've added, not necessarily estate planning related, but more community related. So that's the update there. And then also on the left side, you're going to see a green sheet. So we got a couple of updates for you this morning of things that you'll be able to check the box here of action items that you want to do moving forward. And so I'll explain this as we get into the presentation. But this will be a sheet that I'll reference towards the end of the presentation that you'll want to check the box accordingly for what you need to do, and then you can return it to us or mail it however you'd like to do that. But you could leave them at the tables too on your way out. And then, as always, we have the printout of the PowerPoint presentation that we're doing this morning. And we printed it out so that way you can take notes as we go. With printing it out like that, the slides are a little small, so if you can't read the screen or read what's on the PowerPoint slides, just let me know. I can explain and read what's on the PowerPoint slide, or go a little slower. Just let me know. Okay, and then on the right side, you're going to find your asset list in here. And again, we'll go through this at the end of the presentation. There's also going to be the white sheet, your client update form. This is just the normal action items that we have every year for things that you want us to do, or reminders for you to complete with your estate planning. And we have that green reminder. That green reminder there is to remind you guys to do your part in keeping your plan updated as well, and updating like your personal property memorandum, doing your funeral policies and things like that. So again, I'll go over this more during the presentation today. Okay. All right, so we're going to get started with our 2024 annual client meeting. So as you can see, I don't have my husband and my little boys with me this morning. They're not here to tip over coffee, which is good. I don't know if anyone caught that last year, but we almost lost the coffee pot. So
my husband is actually out west, western South Dakota hunting for mule deer, and so he's gone, so then that means there's no one to bring my kids here. So they're with the babysitter and things, so I figured I would at least show some photos for you. I think every year I talk to you about how they're obsessed with rodeo and bull riding and things, so still in obsession there. There's a picture of them at the rodeo in Brookings, South Dakota recently, a couple weeks ago. So, and remember, I'm from Elkton, South Dakota, so going back to Brookings is kind of the hometown area and to see family that's still back there. My husband, Jesse, so this is his buck that he shot during archery season this year. I don't know if it was end of October, I can't really remember, but he got that south of Lake Benton with his bow, and then literally right before this started, I checked my phone and I had a message from him, and he had just shot a really nice mule deer out west this morning. So the hunting trip worked out. He's got a buddy with him that hopefully can get one too. So then you can get back early and help with the crazy little boys, right? And then we have the picture of them too in front of our house after we carved pumpkins and things this fall. I should add, so Holton, my oldest, he is now 6. He turned 6 on October 12th, and he's in kindergarten this year here in Wyndham. Bo is the youngest, so Holton is the one in the black on this top photo, and Bo is the one in the blue. So Bo is 4, he's going to be 5 in April, and he's in Forest Preschool here in Wyndham. All right, so we're going to jump right into the firm update. So not a lot of things have changed since I took over. Last year was a big change. So the Ford & Musfield Law Office, where I am the sole owner and attorney, and Hannon's name is still in the office name because that's what people are familiar with, but it's just me who owns the firm. And as all of you know, he moved to Missouri. He started a new office in Missouri, and that's going really well. He got it all up and running, and he's doing good there. So he still is of counsel with the office. So with things with South Dakota that I need, I'm still in the process of getting my South Dakota license. Hannon is licensed in South Dakota, so then I'm able to do the South Dakota Trust, South Dakota LLCs, and South Dakota deed work through Hannon with being of counsel. And I still talk to him a couple times a month, just, as a mentor and help me with things. So he's still involved a little bit. So our office obviously located on the square, for those of you who don't know, in between Shannon Lynn's Boutique and the OK Boss store. So it's just north of the courthouse there in the square. But I continue to travel to you. If you need me to travel to your home or meet you halfway somewhere, I am absolutely willing to do that. I'll do like up to an hour and a half is what I'll do. So it seems to work out pretty good. Okay, the office personnel. This hasn't changed either. We still have Abby and Allison. Abby, raise your hand. Allison. Allison's in the back over there with glasses on her head. So Abby is still the heartbeat of the office, right? She is our office manager, our client service representative, long-term care planning coordinator, and legal assistant. So I think almost all of you have seen or talked to Abby on the phone or stopping in the office as the welcome face. So she's the one who really helps keep all the day-to-day things, the daily client things moving. So everyone give a round of applause for Abby. Thank you, Abby. And Allison is our funding and administrative coordinator and legal assistant. So she's the one who is helping me get your trust funded, getting assets transferred to your trust, making sure the new assets get transferred to your trust as part of life plan, and also when someone someone passes away, she's helping me administer the trust and get things distributed out to the kids, or however it's going to go, if it's first death or second death. So Allison is there to really help keep that moving and make sure all your plans are funded. So thank you, Allison. Round of applause for Allison. Okay, the education and training. So part of this annual client meeting and part of Life Plan is that I am attending trainings on estate planning and elder law every year to make myself better, to be the best attorney I can be for you guys, and to make sure that your trusts and your estate planning documents are up to date and the best they can be. So this year in January, I attended the Heckerling Institute. Some of you probably remember this because Hannon had always went to it over the years. So it's the Heckerling Institute on Estate Planning that's in Orlando, Florida every year. So I went to that right away at the beginning of January this year, and Hannon was there too. So I don't know if you guys follow us on Facebook, but we posted a photo of us there together. So that's always a very good training where we can learn from all the national estate planning and elder law attorneys of things they're doing, things that we can do better. So. And then I attended the 2024 Minnesota Elder Law Institute. So that's where I brought back a lot of things. A couple of things we're going to be talking about during the presentation today. So that's always a really good training to go to. And a couple of the other ones, I did some trainings on retirement benefits, Medicaid crisis planning. I did the Advanced Estate Planning Summit and Elder Law Immersion Camp with Wealth Council. So those are the trainings I did this year to make sure I'm staying up to date and making sure your plans are up to date with the new and upcoming things. Okay, so activities and awards. I already talked about, I'm now part of the Windham Chamber Board, and this year we were a little late to the game, but this year we did our ribbon cutting with me taking over the office. So that is the pictures that you see below is the ribbon cutting that we did with the Windham Chamber officially welcoming us or starting the new office. So that's what that is. I continue to teach multiple community education courses in estate planning. I am still going all over the community, doing community ed courses on estate planning and elder law. Seems to be, I typically have one almost every Thursday. In the winter and spring, I believe, is when they do them. So continuing to do that, and you can always check our website if you want to attend one of those, just as a refresher. You can find those on our website, the workshops that I offer, and then also if you follow us on Facebook, we're posting on Facebook any of our upcoming workshops that are coming up in the community. Okay, so looking forward, still working on that South Dakota Bar Administration. Like I said last year, the application's very lengthy and things, but I'm working on that, getting that going so then I can be licensed in South Dakota and wouldn't have to co-counsel with Hannon, but it still works smoothly. I can still operate just the same with co-counseling with Hannon for any South Dakota clients or anything we need for South Dakota, like South Dakota LLCs and things. So, and also still working towards that certified elder law attorney. I probably told you last year to become a certified elder law attorney in Minnesota, you have to have like at least 3 years of estate planning and elder law. So since I started in 2021, now I should have all that covered, and now this coming year I can really gear up and meet that qualification to take that big test and become a certified elder law attorney. All right, so some other resources to find other attorneys that specialize in estate planning and elder law just like me. So, you know, a lot of you, you know, you may have properties in different states. You know, if a lot of you Snowbird, go to the south, and you own property there, we need to be able to get those properties transferred over to your trust. So we use these resources too to find attorneys like me in other states that can help us with your estate planning needs and help draft deeds in other states. But we have these resources here for you too if you ever need to look and see if you can find an estate planning and elder law attorney in a different state. You can go to estateplanning.com, NALA.com, National Academy of Elder Law Attorneys, and the last one on the bottom is National Network of Estate Planning Attorneys. So those are always really good resources that you can go to if you need to find an attorney in a different state. All right, so what everyone comes for, the 2024 updates. So nothing too crazy with it being the election year. There's nothing too crazy that has gone through or passed. So we don't have to worry about a lot of that. And with Trump being elected and with the Republicans taking over Congress, we should, as far as it comes to taxes and estate tax and things, everything should still be good there, and we aren't going to have to worry about extreme estate tax exemption cuts or anything like that would really put our planning into chaos to deal with lower estate tax exemptions. So that's always good news with the estate tax side of things, with how the election went. So we're going to talk about the federal and state estate tax and gift tax updates. We are going to talk about a disability panel update. So this is something that I've noticed over the last couple of years that has been a problem, and so going to talk to you all about it and how we can make that better, and you can check that box if you want to do that. So I'm going to explain what that is here in a couple of slides. And then last year, you probably heard me talk about the Medicaid Asset Protection Trust, the MAPs that we call them, and how I just started doing them last year with the case law that went through Minnesota to be able to do those irrevocable trusts now to protect assets from the nursing home. Well, this year already there's been some new case law with it that I need to update you on. So we're going to be talking about that. And I also talked about the Corporate Transparency Act for those of you who have LLCs, partnerships, S corps, any kind of entity like that you file with the Secretary of State. There has been some updates with that too, and I want to talk about those letters that you may have gotten in the mail about us helping you with the reporting you need to do under this Corporate Transparency Act. Okay, so estate and gift tax update. So good news, the federal estate tax is going up. Again, next year it's going to $13.99 million per person. It's $13.61 million right now, so going up. Now, there's still that prediction that as of January 2026, that the federal estate tax exemption is going to sunset and go down to around $6 million per person. So now with Trump being elected, I've been reading a lot of articles and looking in at all these emails and articles of other estate planning or financial planners around the nation, and I've been seeing that they think it might be likely now with Trump being elected and with the Republicans taking over Congress, that it might be likely that they're going to extend this, that it's a little bit more likely this might not happen in 2026. But again, we don't know for sure. You never know, it could still happen. So keep an eye out for that. I'll keep you updated too, obviously, for next year on that. But it's a little more likely it may not happen in 2026. The annual gift exemption has also increased again by 1,000. So it's 18,000 per person right now that you can get before filing that gift tax return. Next year, it's going to be $19,000 per person per year. So also with that, your lifetime gifting exemption, remember that follows your federal estate tax exemption. So next year, your lifetime gift tax exemption is going to be the 13.99. So you have 13.99 million to use and gift during your lifetime before you would have to pay taxes on that gift. So that's something that's really good. I've had a lot of clients who have been planning according with that, and the possibility that that's going to go down to around $6 million in 2026. So then your lifetime gifting exemption goes to $6 million. So I've had a lot of people being proactive about that, and it's kind of pushing them into doing some gifting now while they have such a high estate or a high gifting exemption, knowing that they're not going to have to pay taxes on that. So that is something too that's part of your checklist on that green sheet. Is we did provide a section for a estate tax planning meeting if you want. So to be talking a little bit more about where you're at right now with your total estate, or do we want to be cautious and plan in case this estate tax exemption, the federal, goes down to $6 million, and talk about if we want to be gifting to plan for that while you have a high exemption. So for any of you who want to have that meeting with me to refresh and talk about that, you can go ahead and check that box on your green sheet, and then we would give you a call, Abby would give you a call to schedule that meeting. Okay, Minnesota state exemptions. So I've been looking all over, using all my resources and things, and I haven't seen anything about it changing. So as far as I know right now, it's going to stay at the $3 million per person for the Minnesota state tax exemption. So obviously we still have some estate tax planning to do there if any of you are trying to avoid to pay little or no estate taxes to the state of Minnesota. So again, that's something you can check the box. If you're worried about the Minnesota estate tax exemption, you can check the box. We can have an overview, look at your assets, and see what we need to do for your planning. And there's still the extra $2 million. So the farm and small business exemption, where again that goes with the homestead classification, farming for 3 more years, among other things. But there could be a chance that your state might qualify for the extra $2 million on debt, but it's not automatic. You have to, your state, or whoever's in charge of your state, needs to file that to see if you qualify for that exemption. So it's something that helps a little buffer, but again, not automatic. Okay, the disability planning update. So what I kind of gave you a hint at earlier is I've been seeing and hearing from clients a problem with the disability panel as far as the doctors that are involved with that. So if you guys remember, your disability panel is going to be located in Article 4 of your trust. If you're married, single, it's always going to be Article 4. And it is going to be 4.02A1 is where your disability panels are going to be located. And they consist of that medical component and a family component. So we always want to make sure a doctor's involved. And so when you sat down with Hannon to decide this and who your doctors would be or me, we talked about, you have the option where you can just choose one doctor, or you can choose 2, you could choose a doctor and a specialist. So now what we've been seeing is as clients are needing to enact this disability panel to deem an individual mentally incapacitated to remove them from being in charge of their finances, clients are finding it very hard to get two doctors to sign that certificate of disability. So the update with this year, my recommendation is for all of you to look at your Article 4s, your disability panels. Look at the very top of your disability panels where it's going to list the doctors before your family. So look at that. If you have more than one doctor listed, I would consider changing that and amending that to just one doctor. Again, because it's become kind of a hassle for the family to get more than one doctor to sign that. So if you have more than one doctor listed on there and you want to change it to just one doctor, go ahead and check that box on your green sheet. So that way we know you want to do that, and we'll get that in motion for you and contact you to get that amendment done. It's also in the definitions part of your trust. So we have the disability panel where the doctor's involved, but also in the definitions of your trust, it's going to talk about when you're deemed mentally incapacitated or what mental incapacitation means. So it's also going to be there as well. So if that says more than one doctor, too, will amend your trust in both Article 4 and it's possibly Article 17 or 13 there. We'll amend that in the definitions as well to make sure it's only one doctor if that's how you want it. So the definitions for in the married couples trust is going to be typically Article 17. For single individuals, it's going to be Article 13, typically. Now, if you have other extra things or kind of a blended family trust, and it may be a little different, but almost all of you is going to be those articles. Okay. And I also, at the beginning, I always like to say to you, if you have any questions, you can go ahead and raise your hand. You can ask questions during, and we'll get a microphone to you to ask any questions. And there's going to be time afterwards as well to ask any questions that you may have. And I invite you, if you want to come up and talk to me more one-on-one after, I will be here for that as well. Okay. The Medical Assistance Trust, the MAP, Medicaid Asset Protection Trust. So this is going to be part of our update, but also part of the education piece today, too, of the meeting is a refresher of these Medicaid Asset Protection Trusts, these irrevocable trusts that you can do to protect assets from the nursing home. So, like I said, in 2021, there was case law that went through the Minnesota court saying that the irrevocable trusts have to be allowed again for clients to be able to protect assets from the nursing home. So after 2005, the laws changed and we weren't able to do that. So basically the whole time Hannon owned the office, the laws weren't allowing him to do these irrevocable trusts, and Minnesota Medical Assistance wasn't allowing it. So now, as of last year, I started doing them because the Minnesota Medical Assistance has recognized it in their manuals as of last year. So that's when I started drafting these. And so with these Medicaid Asset Protection Trusts, what you do is you pick, you figure out the asset that you want to protect from the nursing home. Typically, it's going to be the real estate, and that is the easiest asset to be able to transfer to this. Because when you transfer assets to this irrevocable trust, the grantors, you guys, mom and dad, you lose the control of the assets in this trust. You cannot be a trustee anymore like you typically are in a revocable living trust. So you can't have any access or control of, for sure, the principal, and you can't have So like the principal, the real estate that's in it, you know, if it, you don't have any control to sell it, or the idea is for it not to get sold, but if it got sold, right, you can't get that money from that. So with that though too, you're still essentially gifting to the kids, but it's a way better option than what we were able to do before, where we were just gifting to the kids in their individual names, because of course there come all those consequences and downsides to that. So being able to still gift to the kids ahead of time to protect from the nursing home in a trust is great, because then we can keep those creditor and divorce protections. So when it goes to the kids in this irrevocable trust, it's not owned by them in their individual names. It's owned in the name of the irrevocable trust, where the kids are trustees. So it provides that protection of that asset still from divorcing spouses, creditors, and things like that. And then on that, they can still pass down in those protected trusts to your kids, grandkids, and through the bloodlines as well, with that bloodline protection to make sure it stays in the family and doesn't go to spouses or divorcing spouses. So with that gifting, there's that 5-year look back for medical assistance. So when we gift into this trust for the kids, it triggers that 5-year look back for medical assistance. Medical assistance says that you cannot qualify for medical assistance if you have gifted any assets or transferred any assets for less than fair market value in the past 5 years. So that's something we still got to look at, and so I recommend too that we have a box there to check for these trusts, the MAPs, and medical assistance planning, that if you haven't done so already, you can check that box and schedule a meeting with me to go over this, because as most of you know, it's not just as easy as just transferring the deed over to the kids anymore. We got a lot to think about and downsides to that, and gifting consequences and things. So before you just up and gift, I recommend talking to me, because we need to make sure that you're not putting yourself in any kind of financial burden or anything if you're gifting. Because remember, you have to wait to get on Medicaid for 5 years after gifting. So we got to make sure you have enough assets to pay over that 5 years if you go into the nursing home. So there's a lot of things to think about there. I recommend scheduling a meeting and we can go over that.
Just a quick question. Mom and Dad put this into trust. This trust, can they still receive income, like rental income off that property? Or does that income have to go to... Right. You know what I'm talking about?
Yep, and you're talking about this irrevocable trust.
Right. If the property's in that, can Mom and Dad still receive rental income like off the land?
Right. So her question was, if there is real estate in this irrevocable trust and there is land rent coming in, can Mom and Dad, the ones who created this irrevocable trust, still keep the income? So that is my big update this year. So with that, it was that we were saying, yes, you can keep the right to income, right to reside, like if you're where you live, you've transferred it into this trust, right? So it helps protect it. You can still get the access to the income and things, and it'll still protect that asset as far as Medicaid medical assistance eligibility. That asset won't count if it's been over the 5 years of gifting. But there has been a case, and since I've done some medical assistance trusts already, there has been a change in a case that has gone through the Minnesota Court of Appeals with how estate recovery is going to be affected with these trusts and these irrevocable trusts. So I am being a lot more cautious now with how I'm drafting these and making sure that clients don't have access to the income, don't have right to reside in things. So the case law that went through this year, this lady created an irrevocable trust. She was on medical assistance. She passed away. So legally, the state can recover. And I'm going to go over that too as part of the educational piece about estate recovery. So the state can recover anything that's in your estate, in your, that's in your name, even in living revocable trusts. So this case where this lady had these assets in an irrevocable trust, the county took them to court saying we can recover off of this. We can get some money back for the money we gave to her for paying for her nursing home. So, and the Court of Appeals said it is recoverable. So that is kind of a big update here where this lady had right to income, right to reside. She had other factors involved too. She had the ability to change trustees. She had the ability to change where these assets were going to go in this irrevocable trust on death. So there was a lot of factors that played into this. And in that case, and unfortunately we only have one case so far. So in that case, the court said that the assets in there, because of all of those factors, they're going to say that those assets are part of her estate. They can legally recover and put liens and recover their claim on the assets there. So moving forward, again, I'm being cautious about how I draft these. I'm telling clients the safest option, right, to protect it on death as well is the no right to income, no right to reside. We're cutting all those ties with the assets, so then that way the state can't come and say they can recover it on death. So now, for those of you who have already done Medicaid Asset Protection Trust, you're probably freaking out. You're like, okay, great, now what? But it's okay. With the irrevocable trust, we have that trust protector provision in there, if you remember that. So then that way, the trust protector, which is usually designated me, that I can go in there and amend and change things like administratively as the laws change and help, take and remove powers and things. So we're going to be able to fix this for those of you who have these, but obviously I recommend, that's another reason you want to check that box for the irrevocable trust medical assistance planning. If you already have one of these trusts that has income, right to reside and things, check that box to talk to me. We need to review it and see how you want to proceed. Obviously, you could just leave it alone, right, and risk it and gamble, and maybe you're not on medical assistance and the state doesn't have anything to recover and it's all fine. Or maybe the state decides not to pursue it on your death and not mess with it and try to recover it. Obviously that's a risk and a gamble. So the safest way to protect it is to not have that income or right to reside or any of those things. Also, a lot of you who maybe have done these trusts with me so far, they may have right to income, right to reside, and that's it. So that's another reason we can talk about, and maybe you decide to be like, we're just going to leave it alone, we're going to see what happens, because the only case that's out there right now had all of those factors, right? Even more factors that we haven't put in our trust. So that's what's hard, is we don't have any other case law to see what the courts and the judges are going to do with the different fact scenario and things. So make sure to check that box if you've already done this. Talk to me. We can fix it if we need to, but we can also decide whether it's a good decision to just leave it as well. So that is a big update with the Medicaid Asset Protection Trust is changing it to not having any right to income or right to reside. So of course, that becomes another big sticking point with whether you want to do these trusts, because maybe you need that income to get by with your daily living expenses and things. So again, it becomes this conversation with me where we kind of got to figure out what are your income and expenses, you know, are you comfortable with that? Will you be okay with not having land rent, for example? With these irrevocable trusts, your kids are typically going to be the beneficiaries of it during your lifetime. So you always have the backup plan where the kids could take out the income from the irrevocable trust and pay an expense directly for you. They cannot distribute it back to you, but they could take that income out of the trust and help you with any expenses you need. So as you can tell, it's something we really have to talk about, spend some time thinking about, to see what the right decision is with these trusts. Okay. Next, I'm briefly going to touch on the Corporate Transparency Act because I know not everyone has LLCs, partnerships, S-corps, or anything here, but something we still have to talk on because some of you do. So that Corporate Transparency Act, again, a refresher, a little training part of this is that went into effect as of January 1, 2024. And that requires corporations, LLCs, any entity that has to file their business with the Secretary of State, they're going to have to file this new report under this Corporate Transparency Act. So they have to file what's called a beneficial ownership report with FinCEN is what they call it. So the people who have to report, so basically if you have any of these entities, you're going to have to report. Like I said, anyone who has to file with the Secretary of State would have to do these reports. So the beneficial owners are going to be those who own at least 25% or more in the company, and those who have substantial control, management over the company. Those are the people that will have to report their information on this report, provide their driver's license, and for those entities who were created before 2024, the big update and reminder for you all is you have to have this report done by January 1, 2025. So you have to have it done by the end of the year. Now, another update with this is of course there's been some case law that went through this year after it was enacted. And there's a couple cases, but the one National Small Business case is the court did deem the Corporate Transparency Act unconstitutional in that case. So it's likely that this requirement in this law isn't going to stick around, but as of right now, it's still in place for everyone else except for these plaintiffs, is what they're called. These people who have brought it to court to try to get out of this requirement. So it's only in effect for those where the judge says, yep, it's unconstitutional for you, you don't have to do it. So the rest of us still have to do it until further notice. So they're due at the end of this year for those who have created LLCs before 2024. Those who create LLCs in 2024, you had 90 days to report, and then those created after, you have to file that initial report within 30 days. So with all of this being said, if you have an entity like this, you should have gotten a letter in the mail from us explaining this Corporate Transparency Act and this beneficial owner report that you have to do. And we told, in this letter, we had said, if you would like us to file this report for you, please let us know. We will charge $100 per LLC to do this report for you, to get it done before the end of the year. But you would need to get us some information, right? Most of the time, if you have your entity with us, we're going to have all the information we need except for a copy of your driver's license. So if you want us to do it, you'll want to let us know, you'll want to return that piece of paper. I can't remember what we did, whether you just call in and let us know if you want us to do it. But please let us know if you need us to do it, because remember, we only have like a month and a half here. So let us know if you want us to do it. Get copy of driver's license and the checks. Yes.
What are the penalties for not filing?
The question was, what are the penalties for not filing? So I don't remember like the exact dollar amount. Like I think, what is it, like, is it maybe 500 per day that you're late or something? There's a certain dollar amount that you're late on recording this. So they can get you with penalties, and they also, you know, threaten jail time and things like that. What I've been hearing though is since this has already been contested and is getting contested by more and more people about its constitutionality,
what we were seeing was that it was $540 a day up to $100,000 that you could be fined. So once it was, just hold on, sorry. When we were looking it up, it was, I believe, either $540 a day or $590, I can't remember, one of those two, and then it was like up to $100,000, so you could be fined that much every day until it hits $100,000. So it's a pretty big penalty.
But with that being said, like I was saying, with this being challenged more and more, and likely that it's just going to get overturned, is the talk, right? Is that they're very likely not going to pursue those penalties or anything if you don't do it. Again, we don't know for sure, but you know, you just want to, you know, again, take this option, get it done at the deadline that you need to. Okay. And then on your green sheet, there's another box there. If you need us to complete that report for you by the end of the year, please check that box. Or, you know, you can call us as well. And then also on this green checklist, there's lines there for it's which LLC. Some of you may have more than one entity. So if you want us to file this report for only one of your entities and not the other, you know, make sure you write the entity that you want us to file it for, all of them, you know, so then that way we know which report we need to do. Because we do have some clients who have separate entities before they came to me. We're not filing those reports, but then they created another entity with me and we'll file those reports. So we have to be sure which ones we need to do for you. Okay, another overview here of our life plan maintenance program. So, as always, the fee to be in life plan is not changing. It is $325 a year to be in life plan, and what that gets you is phone calls with me relating to your estate planning questions at no additional charge. In the past, I always said free, you know, and Hannah would be like, well, not technically free, right? But no additional charge after the $325. So the phone calls. So I always recommend utilize those, you know, you don't have to pay for those. Get a phone call scheduled with me and get those questions answered. And typically we can get them answered by a phone call without doing it in person. An in-person meeting in Life Plan is still charged hourly at $2.50 an hour for in-person under Life Plan. So that's where I recommend use those phone calls to get your questions answered so it saves you money. Another thing too is if you need to have an in-person, but we're talking about medical assistance planning, the irrevocable trust, or if we're talking about LLCs, that's a separate planning that I would do a free initial consult for those. So if you are in life plan, but we need to have an in-person to talk about LLCs or irrevocable trusts, then that is going to be no additional charge with that free initial consult for that new plan. Also, with life plan, it also gets you changes to your documents. If you need to make any changes according to what I recommend at the yearly meetings, or according to law changes or personal changes, you can do all those changes while you're in life plan, again, at no additional charge. Also, your asset list that you have, changes to that as your assets change every year. We will update and change that for you at no additional charge with life plan. And then, of course, you get invited to this meeting where, we have the coffee and donuts and other snacks for you, and that's my responsibility to update you every year on what have I learned from my trainings about ways to be better, do planning better, that I can bring back to you to make your plans the best they can be. Letting you know about law changes, tax law changes, and things like that. So, and another thing that I think some people might forget that's included with life plan is if you are in life plan at the time of your passing and your family wants to come to me to help with the administration of your trust, that first initial meeting with your family would be no additional charge if you're in life plan in the year you pass away. Otherwise, please remember that administration charges are charged hourly at $2.50 an hour. So it's separate from your initial setup fee that you did when you set up your trust, and it's separate from life plan except for that first meeting. Then after that, everything would be charged hourly for the administration work. If anyone needs a copy of the life plan contract, we do have some at the table with Abby and Allison. So on the way out, if you want to grab one of those to have on hand, you certainly can. And if we run out, just let us know. We can mail you one, we can email, fax, whatever works easiest for you. But just let us know if you need a copy of that life plan contract. Also, in your packets, I believe there's invoices for next year, or no? No. Okay. So those are going to be mailed? Okay. So invoices for next year for life plan. We're going to try to have them in the packets for you, but that didn't quite work out. So it's going to stay as normal. You're going to get them in the mail. We'll start mailing them out towards the end of December. So you'll be getting your invoices for Life Plan 2025 that if you want to stay in Life Plan for next year, you'll send that check for the $325 to be in Life Plan for next year. So look out for those invoices in the mail towards the end of December, beginning of January. Okay, also with Life Plan is we want to make sure that your trusts are funded, meaning that we have your assets transferred to your trust to make sure your plan's going to work the way you want it to, right? The main things to help avoid probate on death for any assets, especially real estate. If it's in your individual name, it might have, of any value, it would have to go through probate. So keeping things transferred to your trust and out of your individual name is something very important, so then that way it is in your trust and it can flow through there as expected as you wanted it to with your estate planning to help avoid probate, and another big thing, to pass down to your kids protected from those divorcing spouses, creditors, and it helps guarantee that those assets are going to stay in the bloodlines. So to keep that updated, like I said, we do the asset list updates for you as part of Life Plan at no additional charge. So that's why we give you the asset list in your folder here as kind of a little nudge to say, hey, if there's anything that has changed over this last year with your assets that you'd like to update, please let us know and return them, and we'll get them revised and updated for you at that no additional charge. Also with that, we're paying attention to when you update your asset list, and maybe you have new assets on there that you've acquired this year, or maybe it's been in the past and you haven't updated it yet, but any new assets that you acquire after your initial setup of your trust, we want to make sure those are getting funded to your trust. So as part of Life Plan, call us up, let us know, you know, you bought new real estate, or you opened a new bank account, you know, a new investment account, whatever it may be. Let us know if you need our help to get it transferred to your trust, right? That is included under your Life Plan. That would be no additional charge to make sure that that asset gets transferred to your trust or beneficiary to your trust. So remember to keep that in mind. Is any new assets that you get, remember we can always help you get them there. Or if you're questioning it too, you want to do it yourself if you're at the bank or you're at a dealership to title a vehicle in the trust, you can always give us a call if you have any questions of, okay, how do I do this, what trust name, and things like that. You give us a call and we'll help you out with that. And then what we do for funding is you know, we're helping you get the assets transferred. We're sending those letters to the companies to get your assets transferred, right? Where all you have to do is, I say, sign here, you know, to get this asset transferred to your trust. We do all the rest of the heavy lifting for you. We'll send it off to that company to get it transferred, and we'll have that company send us verification back that it's been done, and then we update your asset list accordingly in that confirmed column on your asset list that it's been confirmed by that company that your asset has been transferred. And some of you probably heard me talk about this before. It's a team effort with your estate planning. You know, I just specialize in estate planning and elder law. Well, you know, we do dabble in some taxes and things, but I don't know it all with taxes and not a specialist, or with your finances and investments. So I always want to work with your other players involved with your assets, your accountants, your financial advisors, your bankers, life insurance agents. You know, I want to be working and talking with all of them too to make sure that we have a good holistic plan. That maybe what I think is good for your estate planning, we want to know what maybe some tax consequences are for that, because I've been saying a lot lately, especially with these Medicaid asset protection trusts. You guys have all been probably figuring out with a lot of this, you can't have your cake and eat it too, right? There's always going to be something. If you want to do this, there's always going to maybe be something you got to sacrifice or deal with. So we want to figure out what that is. We want to figure out what the tax implications are of that, and maybe you decide that's okay. The benefit to doing what you want to do outweighs any tax consequences or whatever it may be. So we want to make sure we're keeping in the loop with all of the other professionals with your assets. I already talked about how we complete those company forms, prepare the documents for you, and help you get things funded. All right, so the commitment review for our office and you under Life Plan is that's where that white client list action items comes in. As I mentioned earlier, things that we need you guys to do to help us with to keep your planning updated and keep it the best we can be and work the way you want it to. So on your client to-do list there, reminder in that green reminder slip is that personal property memorandum at the back of your book. to fill out if you have any tangible personal property, right? So things that don't have a deed, don't have a title to show ownership. If you have specific people you want those assets to go to, that's where you fill that out. And typically with my experience, the personal property is usually the cause of the family fights. So we highly recommend filling this out. Most people don't. I realize it's a tedious thing to do, but highly recommend it. And what I've been telling clients too is maybe you're not as worried about your personal property as far as what your kids get, but if you have anything that is sentimental to you and maybe you want it to go to a specific child, you need to write that down, or possibly it's just everything goes equally, right? Or another big thing is if you have anything sentimental that you really want to go to a grandchild right away. Because typically a majority of your plans are going to say that on death, all your assets go to your kids. And then on their deaths, that's when it goes to your grandkids. So it's oftentimes there's things, as you've gotten older, your grandkids get older, certain things become sentimental with your grandkids and you'd want it to go to them right away. I recommend writing that down on there and not just leaving it up for chance that your kids will do it and remember that you wanted to do this and things like that, right? So we always recommend filling those out. Another thing on your to-do list is funeral planning. And I'm going to take a look at it here to make sure I'm not missing any other to-dos. Okay, the memorial instructions. So you also have that in your books under the memorial instructions tab. So that is there. You don't have to do it again. It's not anything that's legally binding or anything, but it's one of those things that's a good gift for your spouse, for your kids, that if you have those decisions made ahead of time, who the clergy is, who the readings are going to be, the music, pallbearers, if you have traditional burial, all that kind of thing. If you have that planned out ahead of time and written down for your family, that's a good gift for them. So that way they can just take the time to grieve and not have to worry about the stress of that and making all those decisions and make it even worse of a situation. So recommend filling those out, and then that also leads to that funeral policy that I was talking about. An even greater gift to your family is if you are in the situation where you can do it right now, recommend to do those pre-funded funeral policies where you can go and get those funeral policies prepaid. You go to your local funeral home, you get a can here, you go and get those filled out prepaid, and you get all those decisions made and listed out, even more decisions than are on your memorial instructions in your book. So that's another thing that I highly recommend. And also with that, another reason that I really recommend them is if you need to get on medical assistance at all during your lifetimes, pre-funded funeral policies are going to be exempt. So those are going to be assets that an asset that you're not going to have to get out of your name to qualify for medical assistance. So recommend doing that. Obviously, you've got to be at the place where you're ready to do that, but it's a good thing just to make sure that the process goes even smoother, paid for, detailed out, and it protects from medical assistance. Okay, and then of course, if you have any updates as far as updates to your asset list, right? We want to get copies of proofs or statements of that new asset is what we like to have. If you're wanting us to get that updated into your asset list and help getting it funded to your trust, we like you to get us copies of that new asset, of that statement, to get the proper information we need to add it to your asset list, but also the information we would need to give to the company to get it transferred to your trust. And obviously, for getting us any updated asset lists, getting us this checklist, that green checklist, those are going to be your to-do items. Also, another thing is legal directives. So for those of you, if you're in Life Plan, we keep paying for that legal directives program. So remember, that's that medical card you get in the mail. That's going to have your allergies, medical conditions on it. But it's also going to have a phone number on there. So then that way, if you're ever in a clinic or hospital and they don't have your healthcare documents on file and you don't have them with you, that number can just easily get called by somebody. Legal directives, faxes, your healthcare documents right to that clinic or hospital. Now, when you first signed up for legal directives with us, we sent to legal directives your healthcare directive and HIPAA that you have on file. Now, if those have been changed and things, we got to make sure we keep updating legal directives with that as well. Or another thing that has come up is if your clinic changes, because on your legal directives form, at the time you're filling it out, you're putting your primary doctor and clinic at that time. Well, that maybe could change. So those are things to think about. If any of those have changed, let us know, and we can contact legal directives for you to update your healthcare documents or to update to a different clinic that those documents need to be sent to. And remember too, I think when you are enrolled, they send you a letter to create like an online account. So I think with that online account, you might be able to change or upload any new healthcare documents or change your clinic. But I know sometimes technology can be hard, so with Life Plan, just let us know if anything's changed and we'll update legal directives for you. And of course, if you have any amendments you want us to make outside of this to-do list, that green to-do list with like the disability panel amendment, if you have any other amendments you need us to update, if any other changes have happened in your personal life, if you need to change trustees or how assets are passing on death, anything like that, if you have any other amendments you need to do, write them down there at the bottom of this list so that way we can contact you and get those amendments going for you at no additional charge. Okay. I think that's it for the white client update. Okay, so client to-do list, we were talking about all of that, and I know I've said this, but with Life Plan, always call in with questions. We'll make sure we can get them answered. The girls will try their best to answer any questions that they can. But just remember, they don't know everything I know, and they're not attorneys. They can't give you legal advice. So if it's, if they know that they aren't able to help you or answer your question, they're going to get you a phone call scheduled with me to get your questions answered. And those who are in Life Plan, we're trying to make it that we can get you in with those phone calls within a couple of days or a week and getting those in a lot quicker for you so we can get those questions answered. Our emails to contact us, if you want to email us with any questions or any updates, our emails are there, so you have them printed out in front of you as well. So Allison's email is the first one, then Abby, and then mine. So with taking over the office last year, our emails have changed and we got new emails. Most of you probably have these, but just in case you don't, these are our new emails to contact us on if you have any questions since we took over the office. Another email that you might want to write down is office@forbluffieldlaw.com. So that's another one you can always email, kind of our generic email that we check every day. that we can get to the appropriate person. But you can always email us directly at our emails as well. Question? Okay, that office email. So office at, you're just going to follow this, FordLustfieldLaw.com. Oh, question. Okay. Yeah, or you can just put that pre-funded policy right there in the memorial instructions tab. So the question was, is if you have already done these pre-funded funeral policies and you have this separate policy set up through the funeral home, do you have to fill in the memorial instructions page that we provide for you in your trust book? And the answer is no, because that pre-funded funeral policy is going to have all those questions already designated in this new funeral policy of what you want to happen. So you don't need to do both. And then the question was, is do you put a note there, for your spouses or your kids to know that, hey, I didn't write it in here, but I have a separate funeral policy. So yeah, you can put a note there, sticky note or whatever, on the memorial instructions page that we have for you saying, I have a separate policy, here's where to find it. Or I've told clients, just put your prepaid funeral policy that you get and all those documents from the funeral home, you can just put them right in there behind the memorial instructions tab in your book. Yeah, so the question was, is if you're selling an asset out of your trust, or maybe it's not, maybe it's just in your individual name, but that process of getting it sold and having an attorney involved with like the closing, purchase agreement, deed, and all that. So typically, no, I don't get involved in that. If you are selling something to a third party, and we want to make sure we do it right, there's exchange of money, I always recommend to go to a real estate attorney to do that. So I am not a real estate attorney. Again, I know a little bit to help you. We want to make sure that we can get your assets transferred to your trust, so I do deep work and things there. But yeah, when it comes to things outside of that, selling or contract for deeds and stuff, I'm going to tell you typically that you need to go to a real estate attorney to help you with that. Now, when you sell something or buy something out of your trust or in your trust, so when you sell it out of the trust, that attorney that's helping you might need some information from us about your trust, because there's a couple extra documents that are going to have to be recorded and signed with that deed transferring this property out of your trust to the buyers. So those attorneys can always contact us. We get them the information. We do it all the time. Sometimes the title company or the attorneys involved will just have us draft those certain documents that they need for the trust. And that's fine. If you're life plan, that's no additional charge. So we're still absolutely willing to be involved with the process to make that happen. Or if you're buying something in trust, we'll have title companies, attorneys contacting us too to get the name right and things that they need for the trust. So we're absolutely involved, but I like to also have a real estate attorney involved doing the purchase agreement and the deed work and things. that can do the title search to make sure it's done correctly. Question?
Is there still a step up for real estate after you die? Like on property, on farm land?
Yes, so the question is there still a step up in basis when you die on, like specifically the question was on land. So yes, on death, that is what triggers the step up in basis of that asset. So typically, using a certified appraisal on death of real estate is going to show us here's the new basis, the new value of the land that now gets to go to the kids. So then if they resell it after they inherit it, they're probably not looking at any capital gains tax or maybe little.
Thank you.
And that's something to think about too if you're just going to gift to kids during your lifetime. Remember, you're gifting your basis. So always think about that too, because if they're going to resell it, they're going to probably have some hefty capital gains tax. Now, something with this irrevocable trust, though, what's good about that is we're able to draft those in a way that we can still give to our kids in this trust and keep the step up in basis. So I'm talking about if you're just gifting to them in their individual names. Okay, and then follow us on social media. That's where you can get obviously a lot more continuous updates about what we got going on, workshops, anything like that. So, and also the website. Last year we got that new website up and running. So we have those listed there for you. So you'll have them on your printouts to go check out our website and our Facebook page. We have Instagram and then YouTube. So this YouTube channel is something maybe you want to circle or, make sure you pay attention to, because we've been recording this meeting and we plan to get it uploaded to our YouTube channel within 30 days after today. So if you want to rewatch this, or you have kids, other family members that want to rewatch this meeting that couldn't be here, it'll be available on YouTube. So that link there is at the bottom, and that's where you'll go to find the link for the recording for this meeting. Oh, question?
Are you going to do that for the trustee meeting for December also?
Yes, the question was, am I going to do that for the trustees meeting in December? And yes, we are going to record that as well, and that will be also on our YouTube channel within 30 days from the date of the trustees training. So then that also reminds me about the trustees training. I'm drawing a blank on what date it is in December. Abby and Allison, when's trustees training? Sorry, they're busy.
I think it's the 21st.
21st. They're telling me in the front row, sorry. I know it was a few weeks from now in December. So December 21st, back here at the Community Center, we are having the trustees training. And that's also part of your life plan too, along with this annual client meeting, is that trustees training that you get invited to. And that's when you want to bring your trustees, bring your kids, because that's the meeting where I give that general overview of what one should expect as a trustee, and we kind of go through the trust a little bit. So that's a good meeting for your kids to be at. But again, if they can't be there, it will be posted on YouTube. Any other questions? Yes. So the comment is she was trying to put a vehicle, title it in the name of the trust. And the dealership would not let her do that, and they wanted, they tried to do it. The state wouldn't let it go through. Okay, so the dealership tried to do it, the state wouldn't let it go through to purchase it in the name of the trust. And they had to just get it in their names, the title, and then go and do a transfer title later to transfer it to the trust. So, yes, I'm starting to learn some of this for feedback from clients. Not always do the clients kind of give me feedback on how this goes when they do it. And sometimes I've heard that buying it in trust, you might have to pay more sales tax. I don't know if that's true or not, but yes, there is that possibility that would have to happen, that you're just going to have to get it in your names first and then transfer to the trust. And that's why, too, I let clients know, since there is some of these hassles with transferring your vehicles to the trust, we can have this conversation of what vehicles should or shouldn't be in the trust, right? That's something that there's some leeway there that we're like, okay, you don't always have to have these in the name of the trust. But remember, what we're looking at is whatever assets are in your individual name on death would have to go through probate if they're totaled to over $75,000. So that's where we look at that with the vehicles. We can kind of play around, especially if you have multiple vehicles, multiple trailers, multiple titled things. We can just, if you have two of your main vehicles that are pretty high value, then the recommendation is just to get those transferred over, and all these other miscellaneous ones you could just leave in your individual name if they're going to total to below $75,000. So, yes, there might be some extra hassle with it, and if you're questioning whether it should be in the trust or not, just give us a call. Use your free, no additional charge phone call, and I can help you decide that. So another comment was also purchasing a vehicle and getting it in the trust name, where they didn't have any problems except for that when the name came back, it had revocable in it. And that wasn't part of her trust name, that's on her trust ID card. And so they went around with them and got that fixed and changed, and it went through. So, I get mixed feedback with it, and yeah, it might depend on who you're dealing with, and things. So hopefully you don't have any issues, but just keep that in mind when you're thinking about transferring to the trust. Maybe you lean more on we're just going to keep it in our individual names, and especially if you're a married couple, on the first death, it automatically goes to the survivor. We don't have to worry about probate issues. So, maybe it's something that you're just like, hey, we're gonna have it just titled in the both of our names, and when first one goes, then we can reevaluate then. So, I think there's different experiences that happen, and then also with that, what I want to add, and it's okay that you did it this way, but just remember too that in Article 1 of your trust, it's on the first page in Article 1. I can't remember the exact section number, but it allows your trust to have any sort of different name. So it can be named, something different than the exact language that we gave it. So like it can be shortened. So first and last name Living Trust, and with revocable in there, with first and last name, it would have been okay. It still would work as long as we know whose trust it is. So the name can be changed a bit as long as your name and trust is there. Another question?
Are you going to talk about the medical assistance planning at the trustee meeting?
Am I going to talk about the medical assistance planning at the trustees meeting? Yes, I can do that and give another quick overview because I know it's very beneficial to have your kids there as other ears and sounding boards with that because it's a whole another kind of complex animal, right? So yes, I will do a brief overview at trustees training. Okay, I'm not seeing any more hands, so we're going to wrap this up. Remember to turn in or mail your green checklist and your white checklist or any amendments, asset list changes that you need to be done. And I thank you all for coming again. I'm so glad that the weather worked out and it's not too nasty cold or snowing out. So again, I thank you all for coming and thank you again for all your support, kind of welcoming me with this easy transition with Hannon leaving and me taking over. So I thank you all, travel safe and have a good weekend.